Good morning, everyone. I'm Bob Munao from Alliant Insurance Services, and I have Scott Sinder on the line from Steptoe Johnson in Washington. We're glad you can join us this morning, and I'm going to turn this over to Scott to start the agenda. We should be done in about 45 minutes and have some time at the end for question and answers that you may have. If you have any additional questions after the seminar, please reach out to Valiant, and they will get it to the right parties for any answers that you may need. All right, Scott. Good morning, and thank you.
Good morning, Bob. Thank you, and thank you all for letting me join you today. Scott Sinder. I am a partner at Steptoe Johnson, where I chair the Government Affairs and Public Policy group. I also serve as the outside general counsel for the Council of Insurance Agents and Brokers, and it's really through that work that we have developed our expertise on in the healthcare world and on the ACA in particular. I'm joined on this call not just by our friends at Alliant and Valiant, but also by David Fiakov, who's my colleague at Steptoe and who really helps me, and we work together on all this work. So this is a brief outline of kind of what we're going to do this morning. We're going to give you a brief political update, sort of where we are, where we might go, key dates that are coming up in terms of your employer conformance, compliance, and then we're going to tick through some of the really big issues that I know some of you are grappling with as you're looking to your mandate obligations for next year, including what you do with non-calendar year plans, the 90-day waiting period and the modifications that have been made there, and variable hour employee issues and how you deal with those. Now we're going to turn it back so that we can give you some more as-applied type knowledge and some overview of the DOL audits from Bob. So let's go to the next slide, please. Brief humor. The Supreme Court, by the way, continues to have a potential role in the outcome of the ACA. I'm going to talk about that in just a minute. Let's look at sort of where we are politically. Right now, can you move the slide, please? Right now, we do not know sort of where the Senate will come out. The Republicans need to win 6 seats to take the majority back. Right now, the numbers theoretically favor them because there are many more Democrats that are up this year than Republicans in the Senate, and there are a number of close races in Louisiana, North Carolina, Arkansas, Alaska, Colorado, Kansas, in Iowa where there's an open seat, and South Dakota has now come into play with an independent running there. One of the twists here is that we may not know who's going to control the Senate until as late as January. That's because we could have independents win in 2 states, Kansas and South Dakota, and 2 other states may be unresolved. Louisiana, where they don't do a primary, so they have kind of an instant runoff that's in December. For the 2 highest vote getters, it's very likely we'll have a runoff there. And in Georgia, there's a third-party candidate running who may take enough votes away from both of the other candidates to force a runoff, which would not be until January. Because in Georgia you need to get 50% plus 1 to actually win their Senate election. So there's a lot of tumult. Nobody really knows, I don't think, where it's going to come out, but the outcome could be dispositive for some of the ACA issues. There's still pending litigation. I think that the most interesting one is whether or not you can pay for subsidies, whether the federal government can fund subsidies on exchanges established by the federal government, so the federal exchanges. There was a split in the circuits in the fall. The D.C. Circuit ruled that you cannot under the statute. The 4th Circuit ruled that you can pay those subsidies. The D.C. opinion has gone to the full circuit. That argument will be in the beginning of December. A court in Oklahoma has now sided with the D.C. Circuit's original opinion, also finding you can't pay the subsidies. The ramifications of that could be very large, and here's why. First of all, if you can't receive subsidies as an individual on the federal exchanges, can you move the slide, please? The majority of the states actually have exchanges that are now run by the federal government. So in all those states, you would be ineligible as an individual to receive a subsidy. So that undoes kind of one of the core intents of the statute. But if you're an employer that's based in one of those states, and you have no employees in a state exchange state, then you also don't have a mandate obligation, because the mandate obligations apply only, or you only have a penalty if at least one of your employees enrolls in an exchange-provided plan and receives a subsidy for doing so. So if you have no employees in a state where you can receive a subsidy, you don't really have a mandate. So this could be a very, very significant case. It could be a lot of nothing if the Supreme Court doesn't take review. There's a lot of betting going on both ways, but the truth of the matter is that we won't know until they actually rule. They're going to have 3 shots at this because the Fourth Circuit case is already before the court on a petition for their review, and the other 2 cases undoubtedly will wind their way there if the court doesn't accept review of this issue before then. Can you please move the slide? In terms of the impact, these are kind of the core issues. One is repeal and replace. Many Republicans have been running on that for 4 years. I think it's unlikely, regardless of who controls the Senate, that we will see a complete repeal bill. I think what you will see is something more targeted in terms of an attempt to achieve more modest reforms that make it a more workable arrangement for most employers. And one of the highlights for that could be this 40-hour work week issue. So a full-time employee would be defined as somebody who works at least 40 hours a week instead of at least 30. It has passed the House, and it could pass the House 50 more times without a problem, given the parliamentarian nature of that forum. In the Senate, it really has not moved forward. You could see this, though, as part of a broader budget type of effort or a broader compromise on a lot of the fiscal issues confronting the country if the President is willing to engage in that conversation. When we talked about that subsidy issue that's pending before the courts right now, if that were to go the wrong way from the President's view and the courts were to strike down the subsidies in the federal court, then I think you have a scenario in which it is much more likely that you see some sort of compromise. On the employee choice on the shop exchanges, the following states, and I'm not going to repeat them here, but they will not be implementing employee choice in 2015. This is also something that you could see come to the fore in a political discussion. The House Republicans are now really focused on the improper subsidy payments, to individuals who thought that they should receive a certain level of subsidy, but then at year end, when you look back on their tax income, it turns out that they were over-subsidized and they'll have a repayment. They are concerned about this and all the tumult that it will cause, and you could see this addressed legislatively as well. Can we move to the next slide, please? Now we're going to look at some of the issues that I think more directly bear on your day-to-day lives. The first are the as yet to be issued non-discrimination rules. These rules will generally prohibit an employer from discriminating in favor of a better paid employee against a lesser paid employee in the offering of health benefits. There's a question about how the IRS will approach this. So on the one hand, they could say as long as all full-time employees are eligible for all of your plans, you satisfy the non-discrimination requirement. That's our preferred outcome. The fear is that it will be based on actual take-up rates of your individual plan offerings. And if there's a disproportionate percentage of lower-paid people who participate in one plan or higher-paid people that participate in another, that you will be viewed to be out of compliance. This is how it works in the pension space. The difference is that in the pension space, the employer has the opportunity to fix the discrimination by adjusting its contributions to individual employees at year end to make sure they're in compliance with the non-discrimination rules. From what we've been hearing anecdotally from the service, it sounds like they may take up some sort of a middle ground where they will use the pension type approach as their basic rule, but they may create a safe harbor that says as long as all of your plans satisfy the minimum value rules and or are affordable for all your full-time employees, then actual participation rates are irrelevant. If they were to go that route, one of the things it would do is it would really undermine the skinny plans. So there are really 2 types of skinny plans. One is the skinny plans that are really just free preventative care. For those, they are much less than the 60% minimum value that's required to satisfy this B penalty, the $3,000 per employee that enrolls in exchange and receives a subsidy. But they are, right now anyway, permissible under the rules as they've been issued. There's a second type of skinny plan that's really, I think, called a minimum value plan. And these are plans that have been engineered to take advantage of this minimum value calculator you are generally required to use. Because under the calculator, these plans have excluded hospitalization benefits, and they have still found a way to engineer their plans so that the plan recipients are receiving more than 60% in value under the terms of that calculator. Now, it appears that that is a mistake in the algorithms employed by the calculator, and we understand that Treasury is endeavoring to issue regulations that will fix that while they fix the calculator. I think the problem is if you have one of these plans in place, what will happen? Does that instantly mean that if that's the only affordable plan you make available to some segment of your employees, if it no longer satisfies minimum value, you'll be subject to a $3,000 penalty if they receive a subsidy? It might. People are working with Treasury now to encourage them to only apply any calculator change prospectively so it doesn't impact plans that are already in the market. A couple of quick issues and then we'll move on. One is on employer payment plans. The IRS has issued a notice that's essentially guidance that says that if you cannot pay, you cannot subsidize the premiums that are paid for individuals who are buying their coverage on the exchange. If you do so, they're going to view it as a health benefit, and they're going to view it as a non-compliant health benefit because it doesn't satisfy the ACA requirements, and you'll be subject to the $100 per day per employee excise tax. My understanding from our tax folks at Steptoe is that this notice is likely not compliant with federal law and that this rule would not be sustainable in a court. I think the question is what employer is going to be in a position to be willing to take that issue on. Finally, we have the Cadillac tax issue that's going to come down the pike in 2018. There's now a lot of discussion in Washington, not just about the magnitude of the financial burden, but also the magnitude of the administrative burden and what that will mean. And so that could also be revisited as part of a more global compromise on the ACA going forward. Can we please move the slide? So this is a timeline that we're now in the middle of. I think the really key date is January 1st, 2015. If you have 100 or more full-time employees, then you must offer qualifying coverage to them under the ACA or be confronted with the mandate penalties, as we've discussed with you before. There's a transitional rule that will exempt you from the $2,000 per employee penalty if at least 70% of your full-time employees are receiving qualifying offers of coverage. And we're going to talk about the transitional rules a little bit more in a minute. On January 1st, 2016, if you have 50 or more full-time employees, then you'll be required to come into compliance with the mandate obligation. So unless there's some last-minute action by the administration, I see these as moving forward, and we now have to grapple with what they actually mean. Can we move the slide, please? Let's talk about a couple transitional issues. First, for non-calendar year plans, there's some transition relief that's been extended for both 2015 and 2016. So 2015 for those of you with more than 100 employees, 2016 for those of you with 50 to 99 employees. And essentially, if you satisfy either of these tests, then you are fine, and you can wait until the first day of your first plan year after January 1st to come into compliance with the mandate obligations. If you don't satisfy one of these two tests, then you will be required to be in compliance with the mandate obligation as of January 1, or you start to pay the mandate penalties. One exception to that, if you are in compliance by April 1st, regardless, then you will be relieved of paying penalties for the first 3 months under any scenario, because it would be the first year for which you are subject to the mandate penalties, and it's a transition rule for that new admittance to the mandate requirement. So the tests are that at least using both full-time and part-time employees, at least a third of them are offered, have been offered coverage in the past, and at least a quarter of them have actually taken coverage. If you only want to look at your full-time employees, and that's defined as the 30 or more hours per week, you can't use your own definition, then at least half have to be offered coverage, and at least a third have to actually be on the coverage. for you to qualify for this transition relief. We did get some new guidance. One issue for non-calendar year plans is under the initial rules, it would be impossible for an employee of yours to switch from your coverage to the exchange-provided coverage if your plan date is not January 1st, because it would result in a gap of coverage for your employees. There had been a temporary rule that allowed employers to grant their employees a one-time ability to make an amendment to their 125 cafeteria plan elections and move into an exchange plan and terminate their employer coverage without penalty. The new guidance permits a cafeteria plan to allow employees to revoke their coverage at any time and move to the exchange, again as a one-time Section 125 plan change. You can't have any dual coverage or non-coverage period. This is something employers may offer but are not required to offer. All right, let's go to the next slide, please. 90-day waiting period. So there's a couple ways that this plays through. There's a general prohibition between the time you become eligible for coverage and the effective date of coverage, and that prohibition says that that period cannot exceed 90 calendar days. Under the original interpretation of the statute, that 90 days for anyone who was hired as a full-time employee essentially started the day that individual began their date of employment. Under modified rules that were issued, you are permitted to have a bona fide orientation period. And I read that language to say that, there has to be a purpose for the orientation period beyond extending that 90-day waiting period. And that orientation period cannot exceed 30 days total. And the combination of the two periods basically require that somebody who starts as full-time be on your plans or be eligible to be on your plans on the first day of the fourth calendar month after they start. Now let's go to the next slide, please. Variable hour employee safe harbor. So this is going to be a huge focus going forward for employers who are trying to manage their full-time employee staff and properly calibrate to whom they offer coverage. The variable hour employee safe harbors are only available to employers who are actually offering qualifying coverage to their full-time employees, again defined as 30 or more hours per week. And it essentially allows an employer, from a big picture perspective, when you hire a new employee, if you have a good faith reason to not know whether they're going to be full-time or part-time, so they're not hired into a full-time position, you haven't advertised it as full-time, there's no expectation that they're going to be a normal 35 or 40 or 30 hour per week, every week type of employee, then you can treat them as a variable hour employee and you can delay this 90-day waiting period by imposing a conversion type period where you're evaluating whether or not they are really full-time or not for the succeeding coverage period. So let's talk about ongoing employees first before we talk about new employees. So for your ongoing employees, can you go back, please? Thanks. You're going to have a standard measurement period where you look back over some period of time, and it can be anywhere from 3 to 12 months. And you're going to evaluate over that 3 to 12-month period whether or not each individual is full or part-time by totaling their hours and doing the math. We generally recommend that that period be 12 months. And the reason is that the rules that apply when you apply your determination of this essentially will create a deviation between your measurement periods for part-time employees and your measurement periods for full-time employees going forward. And over time, you will have a mess if you're not using the 12-month period. There may be an isolated incidents where use of a shorter period is preferred for whatever reason, but I think you'd need a really good reason because you may be creating administrative havoc for you. Between the 12-month period and the first day of the application period, which is called the stability or coverage period, you can have an administrative period of up to 90 days where you evaluate, you do the math and evaluate whether or not somebody is entitled to be on your plan. If you've determined that they're full-time, then an ensuing period, which has to be at least 6 months but cannot be shorter than the standard measurement period, they are entitled to be on your coverage. If they were determined to be part-time, then you go through another standard measurement period and do the same evaluation, and they're not entitled to coverage unless or until they would qualify as a full-time employee. For transition purposes, for next year, you can have a one-time transition measurement period for ongoing employees that has to be at least 6 months long. And it has to start no later than July 1st and end no later than 90 days prior to the first day of your first planning year after January 1st, 2015. This doesn't mean you necessarily had to actively be collecting the data as of July 1st. You can look at data that you'd already collected for other purposes, and I know we'll discuss this a little bit later, and you can repurpose it for purposes of calculating this transition measurement calculation. Can we move the slide, please? So this is just a schematic of how this works, and you see that these periods end up overlapping over time. The yellow boxes are the administrative period where you're applying the standard measurement determination from the prior measurement period. Next slide, please. For new employees, and I had mentioned this earlier, if you have a good and reasonable basis for new employees that they are not necessarily going to be full-time employees, and you look to these standard factors. What was the job advertised as? What's the expectation of the individual who's being hired? Who are they replacing? Is the person they were replacing, were they full-time or part-time or variable hour? You look at those sorts of factors, and if you don't know or have a good faith reason to know that they're going to be full-time, you can treat them as variable hour. As a general matter, the initial rules prohibit you from treating somebody who's a short-term employee as variable hour. So let's say you hire somebody to work for 5 months and they're going to work 50 hours per week. Under the terms of the initial rules, that person would be entitled to coverage as a new full-time employee from day one, subject to the waiting period. They've added a concept of seasonal employees, where they say if somebody is typically employed on a seasonal basis for 6 months or less, then you can treat them as a variable hour employee when they're hired. I think that there's two big differences between short-term and seasonal. One is many employers, they hire people on a permanent basis, but because they're hourly jobs, there's a high turnover. So you may hire somebody with no job termination date in mind, but in a convenience store, for example, the typical tenure of an hourly employee is 7 months, even for the managers. But they're not seasonal because that's not employment that you would only hire during a season or a part of the year. And so you cannot factor in the expectation that you're going to have the turnover. You have to treat them as full-time. Other jobs that are typically thought of as seasonal, so outdoor work, country club work, any of those things, you could apply this VHE rule and use that exception. For new employees who are hired as VHE employees, you can take up to 1 year as an initial measurement period to evaluate them and offer them no coverage. You're also allowed an administrative period, but the combination of the two cannot exceed 13 months plus whatever the residual is. So if they're hired on the 1st of the month, they can't exceed 13 months. If they're hired on the 10th of the month, they can't exceed 13 months and 20 days total as a combination of the two. Next slide, please. Let's go ahead and go to the next slide. There's been recent guidance when you have an employee that changes status. And essentially what they're doing is if somebody has already been through the measurement period, then the change in status is irrelevant. It will apply for the next stability period, but you don't need to immediately make a change in your offer of coverage one way or the other. In fact, you're somewhat prohibited, and you continue to apply through the associated stability period that they're currently in when they make the job change, whatever the conclusion was from the prior measurement period. If they're a new employee who's still in their initial measurement period, then they basically float over to the measurement period that would apply to the new position. But the hours of service that they had served in their initial position would be included in that measurement period calculation. Let's go to the next slide, please. So this is a schematic on the status changes that you can study at your leisure, but I think it'd be better now to turn over to some of the tools that you have available to you that folks can use. Can you go to the next slide, please? Next slide, please. All right, so let's turn it back to Bob, and we'll get you up to speed on things that can actually help you comply.
Scott, I have a question about, a lot of the clients have talked about golf courses that say that in the Northeast they're only open for 5 months. So they're open from May to September. They're never working more than 6 months. How would those employers deal with those people that are hourly? So they never work more than 6 months at a time.
Those employers can treat those individuals as seasonal because they're typically employed over those seasons for less than 6 months. Right. The harder issue for country clubs, so this is the difference between, the North and the near South. Our country clubs in Washington, they are oftentimes open longer than 6 months.
Right.
And so when you hire that golf course personnel and you know that you're going to be open longer than 6 months, even though over the course of the whole year they'll be variable hour, if you know that during their tenure with you they're going to work at least 40 hours a week, they are technically entitled to coverage while they are working for you.
Within the 90-day time frame.
Right.
Right.
Plus the bona fide orientation period. Don't forget that.
Right. So it could be as much as 4 months. So some of the golf courses up here that are open more than 6 months have said to us, well, if the 6 months run to September, we just terminate those people before the 6 months runs up, and we hire more people in September, October, and early November because that's the only way we can get around it if they can do that as a business. Now, some can't, but that would be the only way they could kind of massage the rules in their favor. But it's a real problem for the 6 months or longer. A lot of the clubs, as you know, as you get further warmer, it's a much longer period of time being hired.
Right, and it does create a challenge.
Right, correct, no question. So Valiant, other clients are on the line, our Valiant clients, our prospective Valiant clients. Valiant has worked for the last 1.5 to 2 years to try to develop reports within their system that develop the look-back period and average hours report that you can see on this chart. If you're an existing Valiant client, these reports are available for you that'll show you and measure the number of hours someone that are 27 to 32, 35 to 28 hours, so they flip up and down. But what's important to understand is what Scott was saying before. If you hire Johnny or Mary, that an hourly person, and they're starting at 35 hours and you have no real concern that they're going to be ever under 30, they've got to get the coverage within the normal time frame. You can't say, well, I think they might be a 28-hour person and make them go through a one-year look back. Those hourly people that are working 32 hours plus in the beginning, they've got to be covered from the beginning. You can't let them be delayed for an hour later. It's not going to work. And we've had a lot of questions in the last 6 months from clients saying, why can't I put them on the look-back people? Well, they're not, because you hired them at 32 hours plus. They're never going to drop down. They're working in a restaurant in the back of the house, and they're working a 40-hour week, so you can't make them a variable person. It won't work. It wouldn't qualify, and you'd be in trouble for that. Scott, you agree with that?
Yes, sir, I do.
Okay. So, these reports that we have several on these slides. The next one shows you on the bottom left each month that you have the salary of the people, and actually it shows the number of hours worked so that you can calculate if you're going to use a 6-month look-back period or a 12-month look-back period, the total number of hours that individual has to see who makes the cut and gets into the offer for coverage. And this is just primarily for the variable hour people, because now that it's been clarified, you cannot use this on a person that's hourly that is going to be working full-time right off the bat. And you'll see that in these various reports, the first one was a look-back period report, and this next one is a report that shows an average number of hours that goes through this, so that you can slice and dice this any way you want based on your actual industry that Valiant does for you. So it's something that is available. It's now been tested, and it's been perfected where we've seen these reports. They're very accurate and does help a client go through this, because this is not something that's going to go away. And what you have to remember is that as you do this, you're going to be doing the next round of 12-month people that qualify again. So once you do your initial look back, you're going to be doing it every month for the next round of 12-month people. So these reports have to be done continuously during the year once you start your first measurement period. It's going to be done every month, so doing it manually is not going to lead to accuracy, and the government's going to be looking for accuracy when they go through these reports and review employers one-on-one. Okay, the next slide. The last topic that we'll be talking about, and we'll go next one, is that we've uncovered this, and this is another way for revenue to be generated in ACA. And this is something that the Department of Labor has never really done before, but they're actually going through this in terms of their next step in enforcement. They've now decided that they're going to enforce benefit issues and policies that have been around for probably the last 15 years that many employers believe that it's all taken care of by the insurance carriers or that they're all in compliance, and many, many are not. So I'll just go through a quick outline of talk about who's behind it. So the EBSA is a division of the Department of Labor. They're charged with this now, ERISA compliance. And the third bullet's very puzzling to me because I was surprised that they actually put this in print on their website. They're actually saying that they're hoping to collect $1.2 billion in fines in this year alone, which is mind-boggling. And we've seen a huge enforcement since the beginning of May of this year for clients over 100 lives, but also now for clients under 100 employees because they're still looking for the rebate checks that are coming from the carriers to go through that. We've been told that in the New York area, for example, which is covered from Connecticut down to southern New Jersey, that they've added 1,000 new agents to enforce this because they're being paid to enforce the benefit side of the DOL, which is something they've never really been involved with in our viewpoint in the last 10, 15 years. And, you know, everyone believes that the benefit carriers that you have with your benefit plans are going to have all the items you need. It's an employer responsibility. You can't go back and ask your carriers that they're going to help you out because many employers have changed their carriers. Many employers don't have all this stuff in a folder they can give to the DOL when they show up. We talked briefly before about everyone thinks it's for employers with 100 lives and above. They have now gone after employers that get rebate checks, and we all were aware of the fact that if you're fully insured and you had less than 100 people, the insurance carriers have been giving MLR, it's called an MLR rebate check, which is a refund based on the loss ratios that carriers have done. Some of these checks are $10,000, $50,000. They're looking for those to be filed as well because that money is a combination of employer and employee money. Many people also felt that the broker is going to help you. They might or might not, but it's an employer responsibility, so you have to have your house in order. It's not something you can just count on your broker having everything ready for you. And we have actual proof that in these DOL letters, they're giving employers on the initial letter only 10 business days to respond, and we don't believe there's any way you could have all this stuff available for a DOL audit within 10 days. It's actually impossible. And you know, this is really just a call to action that you better start looking at this to make sure you're ready. Why are people out of compliance? The lack of this is coming. The carrier documents are very complex from SPDs to SBCs. I can give you all these letters and stuff, but these are things that you need to be aware of, that they're going to be looking for this stuff. We have access to all the regulations they're looking for and all the documents they're asking for, and I would say that many, many customers of Alliant and around the country are not in compliance with this because they don't have this stuff updated to what the DOL is looking for. And it's just a matter of ignorance on that stuff because the DOL is now focused on getting this as a way to get revenue. Now these are just some of the things that if you have them that are subject to ERISA, just want to see just, you know, paid time off in the 3/4 of the way down is not. Severance policy, yes. HSA plan, yes. You know, dental, medical. If you have a self-funded plan, of course, yes. But these are just some samples of things you could look at. And, you know, these are just, you know, refreshers of, you know, things you have to provide to an employee. You have 30 days to provide an SPD to an employee upon written request. A lot of these SPDs are not accurate and current. You know, you may have dusted something off from 4 or 5 years ago, but you've changed carriers, changed plan designs, created an HSA. These are all SPDs that need to be done and have to be accurate. $110 a day is the penalty. It's not something anyone wants to go through and have to come up with a check on, but when they come knocking, they're going to be ready and they're going to not give you a lot of time to comply. Now, one of the things that we find very curious is that, and this is something that most clients don't have, on top of your SPDs is a wrap document. And a wrap document really is a contract between the employer and the employee. So many employers believe that if they have a summary plan description from their carrier, that they're in compliance with the DOL. The answer is absolutely not, because the DOL is saying to us clearly that where's the document between ABC Corporation and their employee? The wrap document accomplishes that. It's something that most employers don't have. The carriers don't supply this, and it's something that can cost between $3,000 to $5,000 to have an ERISA attorney prepare for you, something we prepare in part of our services for a client, and it covers all the things you need to have, and it's one of the main things that the DOL have in the first 5 questions of their list. And many clients just say, what is a wrap document? So there's a quick piece on what it is. It has to get done. Any employer that has over 100 employees has to have this. It's commonly mistaken. These are just, you know, how do you fix this? Make sure your SPDs are up to date. These are other things you need for your 5500s. SARs are required. And Alliant does this as part of our service. We're They've been a long-term partner of Valiant customers around the country, and we've done this for many, many clients recently, and we have it in the past. One of the things that I wanted to just bring up, and it was in today's Wall Street Journal, so everyone has to want to get a copy. In states that are Democratic, there have been for a lot of the hourly employees an ability to put your lower-paid people, typically people making under $30,000, onto a Medicaid version of medical care that does not have those employees count toward your eligible count. The article today talked very clearly about how that happens. Coincidentally, the Republican states that did not adopt their own networks and private exchanges did not go through this, so your Democratic states have this availability, but we've had very much great success with a lot of hourly groups that have had their lower paid people go on Medicaid, and they do not have to then qualify for the number count that goes through. This is important. I think it'll continue. But Florida, Texas, for example, do not have that ability, but New York, California, for example, have it, including New Jersey and Connecticut. So for the tri-state area, that's actually a very good strategy that was highlighted again today in the Wall Street Journal. And this is just a quick sample of the people that could qualify for that Medicaid. They actually talk about in these laws now that it's not a married couple, but if someone's boyfriend, girlfriend, and they have 2 children living in that apartment, they could have they'd be considered a family of 4 and could earn up to $32,913 in this chart and qualify for the Medicaid if that state has it available. So many of our clients within Valiant on our own have a lot of employees that are in this age bracket and salary bracket where they can actually qualify for this. It's actually a very interesting strategy to get them outside of the count of offering medical coverage. And they get the coverage for free, so it's a great tool if an employer provides this. Just a quick summary of the things you need to be looking for in the next 12 months. Make sure your health data is analyzed. Make sure you've got real good controls. The Valiant customers have real good tools to put this up. Be prepared for all the ACA requirements because the clock starts ticking in 2015. So this is something that we're worried about what Scott mentioned, but also that the DOL is going to start knocking on doors. And they can easily do just from a complaint from an employee that left you 2 weeks ago that thought they were going to get 42 hours in pay, only got 37. They can go on a website to complain and whistleblow an employer, and that will trigger this DOL benefit order right in the backside of it too. The third bullet, make sure your employee communication materials are clean and understandable. The disgruntled employee is going to go right to the DOL and say, look, I didn't understand this. There's new technologies such as teledoc that are coming where people can go and call a doctor on a telephone, not see them. It's not being offered by a lot of carriers. That's going to be a new tool. And then, just be aware of this last footnote. This Cadillac tax is probably not going to go away. There's still some possible that in 2016 and 17 that it could be knocked out with the way the Senate and presidency is going to go. But right now, that's definitely on the horizon, not that far away anymore. And do you have the resources to make sure you take care of this? If not internally and externally, between Scott's firm and ours and Valiant, we can definitely help you on any issues that you may have now or in the future to help you with.
Hey, Bob. Hey, Bob.
Yes.
You're going to take. Oh, can I add 2 things to your to-do list for folks?
Yes.
Just quickly. In preparing for the full-time employee issue, one thing you should do is you should reevaluate all your independent contractor relationships and paper your file to verify that you truly are accurately treating them as independent contractors. That's because if you misclassify them and don't offer them benefits, and the DOL or the IRS later determines that they were actually employees, your penalty exposure now has skyrocketed because you could be subject to that $2,000 for each one of your employees, regardless of whether they are collecting benefits or not, penalties. So it's really important that you make sure you feel good about that. The other thing is, in terms of trying to implement a part-time employee strategy, you're going to have difficulty moving current full-time employees to part-time status because you would expose yourself to some ERISA litigation claims. But to the extent you are hiring new employees and you hire them only into part-time positions and you maintain them as such, you'll be able to permanently exclude them from your benefit plans if that's what you want to do. I just wanted to add those 2 things as part of that to-do list and things you can be doing to help yourself now.
Thanks, Scott.
Thank you very much. Thank you, Bob. Thank you, Scott. My name is Inga Spies. I'm here with Valiant. So we are open now for the next 10 minutes for questions. Hope you enjoyed our webinar. and we are pleased to have Bob and Scott on board to support you as well. We can support you with our look-back report and our alerts with our new software tool we are offering. So any questions? Yes, this presentation will be available. I will upload the presentation to our website, and everybody who attended the webinar will receive a link to this presentation.
We're just answering the questions as we see them coming up here. Question was, where can we find the look-back reports? Valerie within Valiant will be the person that you'll be asking for that within Valiant. If an employer has less than 30-hour employees, do we have to offer any medical benefits? The answer is no, but the onus is on the employer to prove that those people do not work consistently more than 30 hours. So if you have only under 30-hour employees, and some firms have said we're going to just hire people that work 28 hours or less, great. If it can be confirmed and documented, you don't have to offer benefits. That's an employer decision. But 30-hour plus, you definitely have to, or face the fine, of $2,000 per employee. The question was, is the webinar eligible for CPA continuing education credits? No, it is not. Several businesses with common owners. We want to confirm that when calculating the total number of full-time employees, we have to go across all lines of business. Yes, you have the control group rules that have always been around before. Scott, if you want to chime in on that too, but if a group has 4 companies owned by different people and it's filed as a control group, they're considered one company.
Yeah, I mean, and so the control business rules are actually somewhat convoluted. But if you have overlapping ownership or control, then you should evaluate whether or not you're a control group. The only significance it has is to determine whether or not the individual companies within the group are large. So if you have 4 20-person companies and they're commonly owned, even though each of the individual companies would not be subject to the mandate on its own, collectively they're 80, so they're over 50, so they're subject to the mandate. But that's the only significance of it. Each of those individual companies can satisfy the mandate or not, however they want to, and they have independent compliance obligations.
Scott, I have one question for you. It says, do we have to memorialize a standard measurement period, and can it change?
Well, if the IRS knocks on your door, and they're going to knock on people's doors, you're going to need to have something in your file that shows that you actually applied the measurement period. Remember, the measurement period is a safe harbor. So it's an alternative to actually looking at somebody every month. And if they're full-time and they didn't have the offer of coverage during that month, you pay a penalty. If they're not full-time, then you're exempt from the penalty for that individual. The problem with many variable hour businesses is some months people may be very busy, there's inventory, whatever, but over time they're not as full-time. And so the variable hour regime is meant to give you stability in how you offer coverage to that employee universe. So yeah, you need to memorialize it. You are permitted to change those periods, but in doing so, you cannot truncate the stability period rules that apply to your prior measurement period. So if somebody was found full-time and used a year measurement period, then they're entitled to a year of coverage. If you later decide to convert to a 6-month measurement period, you couldn't apply that to that full-time employee until their year of coverage was done. So the effect of the 6-month measurement period could not be implemented effectively until that prior stability period concludes.
Scott, one more question. Well, there's a couple more, but it says, can you elaborate on the 9.56% that the employer has to pay? Why don't you start with that, and I'll give you some practical solutions to that as well.
Sure. And so in order for coverage to be considered affordable, then the amount of premium paid by the employee for individual coverage cannot exceed 9.56% of their Box 5 W-2 income. So that's basically all their normal employer compensation. The employer contribution to the premium is irrelevant in that calculation. It's just what the employee has to pay. If there are no affordable options for a lower paid employee, then they are entitled to go to the exchange and receive a subsidy, assuming that their income qualifies, so they're between 100 and 400% of the federal poverty line. And the employer, if they do receive that subsidy, would be subject to a $3,000 penalty for each employee that is so subsidized. So that's kind of the framework of it.
On the back end of that, we've been very successful for Alliant clients with Valiant is that we've developed the affordable plan. People don't like it because it's got such a high deductible, but that is set at 9.5% of the lowest paid wage earner. So a client could have the lowest paid wage earner being $15,000. Another client has a $22,000 lowest wage earner. That is what you set the single rate for the medical contribution for that high deductible plan. It's not going to be a $500 deductible, $10 copay at the doctor's office. It's going to likely be a $4,000 deductible applied to all expenses, has hospital coverage, covers it with an out-of-pocket of $6,000 overall for the individual, and that's the plan you're going to charge, let's say in 2015, $110 a month for single coverage. We find that most people don't want to buy it because it still costs them $100 roughly a month in contributions out of their paycheck, and it has such a high deductible, they just say, look, I'll still go naked. The only thing that's going to push them is as the individual tax raises up now to the high 300s in 2015, they're going to think about signing up, but they still are going to a lot of clinics for free. As that individual tax starts to ramp up in 2016, you'll have people thinking about it more so, but the fear is not that 9.5% is going to cost you a lot of money. It's getting your insurance carrier to give you that plan alongside your other offerings and then restructuring your contributions so that it's fair and equitable to all people, because that's what part of the law is as well. But it's primarily based on the single coverage. So we got a few more questions before we got to wrap up. You do not mention full-time equivalent employees. What are the implications for coverage, penalties, etc.? Well, in full-time equivalent employees, we're still using the 30-hour baseline as the start. And as we talked about before, for seasonal employees, those are working less than 6 months. But full-time equivalent, you've got, I guess, Scott, that's what you're talking about, the part-time people, and they're going through these.
Well, yeah, you mind if I jump in?
Yes, go ahead.
So the full-time equivalent calculation is only relevant for purposes of determining whether or not you're a large employer subject to the mandate requirements. That's it. So they use a different definition of seasonal employee, and there's a different calculation base for it. I think it's 120 days or less of work, but you're only allowed to exclude a limited number of months in which you have the seasonal employees from the calculation. Basically, you're adding all those full-time equivalent people up, all their hours, to figure out a number of them. When combined with your full-time people in any month, if it's over 100 for 2015 or over 50 for 2016, then you're subject to the mandate. If it's less, you're not. And then you throw out that FTE calculation. It's only relevant for determining whether or not you're subject to the mandate obligations.
Scott, there's a good one here. I just want to maybe end on this one. It says, you see the one on the second at the bottom. It says, what is the definition of common control? My partner and myself hold 60% of 7 restaurants, and my partner and the third party hold 50% each of the 8th restaurant that had 15 employees. With respect to the first 7 restaurants, since
I'm going to stop you.
Yes.
You can't answer a question like this on the phone. It really it's not a one-sentence rule. In fact, I have a memo that's available through our frequently asked questions that I think is about 6 pages that outlines the general approaches to determining whether or not businesses are commonly owned or commonly controlled. You really need an evaluation from your accountant or your tax lawyer on whether or not you would qualify as a commonly controlled business under those rules.
We probably get this question once a week from different restaurants in the Northeast, so it's very common to come up. So I think it's a great answer for that, because that's the long-winded answer we get back on. It's not an easy answer on this one. Another last question says, does Valiant offer full services when it comes to health coverage from administering, tracking, to offering their actual medical plans? The answer is yes.
Hey, Bob, can I just add one qualification to the 9.5% discussion we had earlier?
Yes, Scott.
So under the current regs, that's not adjusted for inflation. That may change, but our understanding is that that's locked at 9.5% for now.
Right. We will make this presentation available to us. And the other questions that we don't have, we have the people that have asked it. We'll try to respond to them directly through an email.
Correct. We will respond to them. We will take your questions, and if you have additional questions, please do not hesitate to call or to send me an email. Thank you